Hey everyone, welcome back to the channel. Today we're stepping into one of the toughest courtrooms you'll ever see, Judge Oakley's. This isn't a judge who hands out gentle warnings or dances around questions. When someone tries to play games here, the consequences hit fast and hard. Today's case features a sovereign citizen convinced he's smarter than everyone in the room, claiming he's acting under duress. But from a very first moment, Judge Oakley isn't buying it. Tension fills the room, and by the end, things spiral completely out of control. Buckle up. This one escalates quickly.
There's actually a project word that was since been signed by a judge. I have lawsuits filed and all of this stuff right now, which I know that they received.
Hold on, brother, wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check or something.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying to be
well,
dismissed.
which one do you want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got sent out past it, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first? You want to deal
my
with
main
the default?
motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, what? Don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
that's the only civil infraction.
I have numerous, lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that chart.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket, because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my attorney.
Well, let me ask you this: did you contact the court?
I was again, as I said, I had no sort of.
Right off the bat, it's clear. The defendant isn't actually answering the question. The judge just wants a simple yes or no. Did you contact the court? Yes or no? Instead of addressing this, the defendant keeps dodging, talking in circles and overcomplicating matters. That's the real issue. There might be a legitimate legal defense right in front of him, but by representing himself and pretending to be a lawyer, he completely fails to use it. No courtroom theatrics can replace understanding the law, and that confusion is exactly what's sinking his case.
This is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
once again, I'm going to draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
What, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than a
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. And I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
On the surface, his argument could have been valid. It's technically a real legal defense. But here's the catch. It only works if presented correctly. And that's where everything falls apart. The prosecutor is moments away from stepping in and exposing the flaw. Once that happens, what could have been a solid defense collapses in real time. A potentially strong argument turns into a self-inflicted disaster. And the courtroom is about to witness just how unprepared he really is.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default of a civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because there's.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object to this.
Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole process. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
The fact that I was threatened to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to
Stop.
me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according. Yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying.
The judge immediately cuts through the confusion, laying it out plainly. The logic doesn't add up. The defendant's request actually works against him. If the default ruling isn't set aside, he's right back where he started, exactly where he doesn't want to be. Silence fills the courtroom as the reality sinks in. At this point, the judge doesn't mince words. This isn't clever. It isn't strategic. And it's certainly not helping the case. One thing is clear. What he needs isn't another speech. He needs a lawyer.
I just set my rights aside.
She's not setting your rights aside. She set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know. Did she address the money?
No, she never did. No one did. It's
Sir,
written in my motion.
Sir, I'm going to hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can.
And that's exactly how Judge Oakley handles it once it's obvious this is nothing more than sovereign citizen nonsense. There's no debate, no entertaining it, and certainly no letting it derail the courtroom. The claim is denied on the record, and the proceedings move on. Anyone unhappy with the outcome can appeal if they wish, but the docket stays clean, judicial economy is respected, and everyone knows the result isn't going to be overturned. It's decisive, efficient, and shuts the door on arguments that never had any legal merit.
District court decisions you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my
object. You can appeal.
motion. But I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honest, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station, and we were in town, and we had, or in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it, went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this day. I've already used this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on.
Now it's time for prosecutor to present her arguments. But an immediate issue arises. She's far from microphone and the audio quality drops sharply. I've done my best to clean it up, but it's still rough. The good news? The argument itself is short and to the point. Rather than cutting or guessing what's being said, I'll let the clip play as is. Afterwards, I'll break it down clearly and highlight exactly what matters, so you won't miss a single important detail.
Accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
because people submit that the investigatory stop exception in Terry versus Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by the Huron Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the law. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right-of-way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why
The defendant's entire case hinges on redefining plain English. He claims a vehicle isn't really a vehicle, and that driving doesn't actually mean driving. Using this logic, he insists he doesn't need a driver's license for what he calls an off-road vehicle, even on public roads, which is illegal. He argues he never entered a contract with the government requiring a license. But here's the contradiction that sinks the whole argument. He has no problem contracting with the government to get a concealed carry permit. In other words, he only rejects the law when it's inconvenient, and that inconsistency destroys any credibility he had left.
All right.
Which
So
I object to the
hold on. All right. So the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay. All right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not gonna plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree
Yes
with
or
that.
no? Mr.
Yes, I agree with
Vito?
that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORV.
your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial, for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand
I don't
that.
think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it's like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that as
Mr.
well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well,
right?
the officer chose to retaliate against me is what happened, Your Honor. Which I
Sure, he could claim the officer didn't understand his sovereign citizen version of the law. But if that were true, the problem isn't the officer alone. It's lawmakers who wrote the statutes incorrectly, judges who interpret them wrong for decades, even Supreme Court justices who already ruled against this exact position. That's where the argument collapses completely. The issue isn't everyone else misunderstanding the law. The problem is that this interpretation exists only in his mind and would never hold up in a real courtroom.
absolutely.
Okay. Do you have anything else to be discussed today on motion day?
We had, as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But sir,
recording.
stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right. Now, Mr. Crusoe, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys that will be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might
comprehend.
say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
none, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can, and that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right?
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
So that's where his appearance ends. Officially, at least on the record. But the story doesn't stop there. About 20 minutes later, after the case concluded, Judge Oakley had an off-the-record conversation with the public defender. This time, he didn't hold back. He openly shared his thoughts on sovereign citizen arguments, why they fail every single time, and how the court handles them once identified. It's a rare glimpse into the honest perspective of a judge when cameras aren't rolling, and it adds a whole new layer to what we just witnessed.
Royce, I was trying to get you some work earlier.
Oh, I almost ran out of the courtroom as soon as you said, I'm happy to assign someone. You would have seen like the cartoons, like you go through the wall and just like the imprintedly go through it.
But these guys kill me.
I've never heard about the travel, like time traveler or whatever.
The last few sovereigns I've had in front of me, honestly, they had decent legal arguments. They just don't know how to get them out,
Right.
The
one that I think.
Not that the traveling's a good argument.
I heard half of it. He
Yeah.
said like whatever he was driving under the definition wasn't like an ATV.
So that might be a good
That
argument.
might be.
Yeah, there's a lot of stuff out there that's like hybrid stuff that since all those ordinances and statutes were written. So there could be something that falls through the cracks.
Yeah, absolutely.
But he's not going to get anywhere with his vitriol.
No, what is this weird thing? What is the trap? I don't understand that.
It goes way back when we traveled, you know,
I know this
without machines.
we have a constitutional right to travel. Is it some kind of like?
That's what they're using. They're saying I've got a constitutional right to travel, and you can't restrict my right to travel by making me have a driver's license.
Okay.
And honestly, my memory stinks, but one of the first things I remember learning in driver's education was, like, day one, driving is a privilege granted by the state of Michigan. It's not a right.
Right.
We'll take that privilege away if you break the rules.
Right. It seems like a pretty reasonable
Yeah.
logical.
Well, and that's what I try to shut them off. It's like, look, I don't buy that argument. I'm going to deny your argument, but go ahead, appeal me.
Right.
You know, if you really think you're on solid footing legally, go appeal me. Circuit court judge can tell me I'm wrong, which ain't going to happen because
Exactly. Not a single one of these arguments has ever worked. Not for sovereign citizens, not for self-proclaimed American state nationals, and certainly not for Moorish claims. Courts across the country have heard these theories for decades, and they fail every single time. There's no hidden loophole, no magic wording, and no secret interpretation that overrides settled law. Recycling the same nonsense only guarantees more trouble and potential jail time. Reality wins eventually, whether you like it or not. And that's where this video concludes. He has another court date coming up, so chances are we'll see him back in Judge Oakley's courtroom soon. If you enjoyed this breakdown, hit like, drop your thoughts in the comments, and make sure you're subscribed so you don't miss the next appearance.